Hello students and welcome to EPG Pathshala. I am Dr. Vageshwari Deswal, teaching at Faculty of Law, University of Delhi. Today we will discuss the module Acid Attacks and the Law for the paper Women and the Law in the discipline Women Studies. In this module, we will try to understand what is acid attack, what are the main reasons behind acid attacks, what are the legislative provisions in our country to deal with acid attacks, and what are the measures taken by the state for protection, treatment and rehabilitation of acid attack survivors. Firstly, let us try to understand what is acid attack. The term which we commonly use to refer to acid attack is vitriolage. This term literally means throwing oil of vitriol. Oil of vitriol is concentrated sulfuric acid. So throwing of this oil on the body of a person with the intent of injuring or disfiguring him. Now the reason could be jealousy or for taking some sort of a revenge. In common parlance, the term vitriolage is used to describe the throwing of any corrosive substance, not necessarily sulfuric acid, on a person with malicious intent. The most commonly employed agent in acid attacks is sulfuric acid, that is oil of vitriol. Hence the name which is given to this offence is vitriolage. Although it has been seen that in many cases, nitric acid and hydrochloric acid are also used. Before 2013, we did not have any specific provision to deal with acid attacks. There was ample discretion with the police to book the accused under a provision of their choice, and they, loaded with their own notions of morality, depending upon the character of the victim, would decide whether the accused should be booked for causing simple hurt or grievous hurt. After 2013, two new provisions dealing exclusively with acid violence were introduced in the Indian Penal Code. Section 326A deals with voluntarily causing grievous hurt by use of acid, etc. It reads, whoever causes permanent or partial damage or deformity to, or burns, or maims, or disfigures or disables any part or parts of the body of a person, or causes grievous hurt by throwing acid on or by administering acid to that person, or by using any other means with the intention of causing or with the knowledge that he is likely to cause such injury or hurt, shall be punished with imprisonment of either description for a term which shall not be less than 10 years, but which may extend to imprisonment for life, and with fine, provided that such fine shall be just and reasonable to meet the medical expenses of the treatment of the victim, provided further that any fine imposed under this section shall be paid to the victim. So you see that now not merely throwing of acids, but administering of acids has also been made a punishable offence. This provision has been very comprehensively drafted so that whether a person is throwing acid at a victim from a distance, or forcing the victim to drink acid, or trying to administer acid with the help of a syringe, or by any other means, if any accused uses acid to harm or cause any kind of injury to the victim, the accused would be guilty, and the punishment has been prescribed as a minimum punishment for 10 years. So this is indicative of the seriousness of our legislature to deal with the crime of acid attacks. And the fine also has not been prescribed, it has not been fixed. What the law says is that the fine shall be just and reasonable to meet the medical expenses of the treatment. Why the lawmakers framed this provision like this was because they knew that treatment of acid victims costs a lot of money. So in case they were to prescribe a fine 5,000 or 10,000 or even 50,000 rupees, so that would not suffice for the treatment of the victim. And further, they have provided that any fine that has been imposed under this section shall be paid to the victim. Then we have got section 326B, which makes even attempts at throwing of acids punishable under the law. Now, this is a provision which is further indicative of the seriousness of our legislators. What it says is, whoever throws or attempts to throw acid on any person, or attempts to administer acid to any person, or attempts to use any other means with the intention of causing permanent or partial damage or deformity or burns or maiming or disfigurement or disability or grievous hurt to that person shall be punished with imprisonment of either description for a term which shall not be less than 5 years, but which may extend to 7 years and shall also be liable to fine. So in order to attract 326B, it is not necessary that actually the victim should be harmed by the acid, or that actually the acid should have been thrown on the victim. In cases where the accused has even attempted to throw acid, or where he has thrown acid but the acid has not fallen on the victim, still those cases have been held as punishable, which entail a liability of 5 to 7 years for the accused person. The explanation appended to this section reads, for the purposes of section 326A and this section, acid includes any substance which has acidic or corrosive character or burning nature that is capable of causing bodily injury, leading to scars or disfigurement or temporary or permanent disability. The significance of this explanation is that it includes any other substance which has acidic or corrosive character. So now it is very clear that acids would include alkalis also. Now alkalis can be more harmful than acids, but technically alkalis are not acids owing to the pH difference between them. So in case the law was only about acids, then in such cases an accused who used alkalis against the victim could easily take up this defense that the substance which he used is not technically acid, so he should not be held liable under this provision. Further, explanation 2 says that for the purposes of section 326A and this section, permanent or partial damage or deformity shall not be required to be irreversible. Now, this explanation is particularly significant in contemporary times because due to advancements in technology and medicine, nowadays the most serious of injuries can be corrected and the most severe of deformities can also be reversed at times. But if the accused has caused an injury which has resulted in a damage or deformity to the victim, even for once, the liability would be there under this provision. Offences covered under both sections 326A and 326B have been made cognizable and non-bailable in nature. Let us understand what are the reasons behind such acid attacks. Now, there is a strong gender dimension behind acid attacks. In majority of the cases, acid is used by prospective suitors to seek vengeance against women for rejecting their proposals or spurning their advances. Sometimes it is used by family members also, such as a husband, for punishing their wives for bringing insufficient dowry, or sometimes when they suspect their wives of having some extramarital relations, when they suspect her of infidelity, then also they use acid as a measure of punishment, as a means to punish the woman. Sometimes it is also used by parents against their daughters for not conforming to their warped notions of traditions and doing acts contrary to their accepted norms, thereby bringing a dishonor or disrepute to the family. Then in cases of property disputes, many times people use assets against the daughters or women of the family of their enemies, because they know that once a person is injured by the usage of acid, now that will set the family back financially also, socially also. The victim would require long treatments also. So the family would be engaged in the treatment of the victim, and the family would have no time left to concentrate towards their disputes. So this is used commonly to settle scores with enemies. Then there is another reason why acid is commonly used as a weapon of offense. The most common reason is because it is easily available. It is cheaply available. It is available over the counter. Despite our having legislative provisions, despite the court issuing guidelines in Lakshmi versus Union of India, the fact remains that even today, if you go to any shop, general shop, and if you ask them for a toilet cleaner, unless and until you specify the brand name by which you want to purchase a toilet cleaner, it is highly likely that what they will place in front of you would be a bottle of acid. And these acids, they are available for as less as 25 rupees per litre. You know, acid is a weapon which is very easy to use, not only to procure, but its usage is also very easy. It is colorless, it can be carried very easily. You can carry it in a bottle, in a jug, in a bulb, in a water gun. It can be thrown from a distance. When it is thrown, it does not create any sort of a noise. So what happens, by the time the victim realizes that they have been attacked by acid, in the meantime the accused gets time to make good his escape. So these are the reasons why acid is commonly used as a weapon of offense. Then we have clause 7th of section 100 of the IPC, which gives a person the right to even cause the death of an aggressor while exercising the right of private defense against an act of throwing or administering acid. So whosoever attempts to throw or administer acid, or whosoever actually throws acid or administers acid, where such act or attempt causes the reasonable apprehension that grievous hurt will otherwise be the consequence of such act. This clause was inserted in section 100 of the IPC via the Criminal Laws Amendment Act of 2013. Acid violence by a family member is also covered under section 3 of the Domestic Violence Act 2005, which defines domestic violence as any act, omission or commission or conduct that harms or injures or endangers the health, safety, life, limb or well-being, whether mental or physical, of the aggrieved person, or tends to do so, and includes causing physical abuse, sexual abuse, verbal and emotional abuse and economic abuse. The explanation clause appended to this section further clarifies that for the purposes of this section, physical abuse means any act or conduct which is of such a nature as to cause bodily pain, harm, or danger to life, limb, or health, or impair the health or development of the aggrieved person, and includes assault, criminal intimidation, and criminal force. So we see that acid violence is covered under this clause. Further, under clause C of section 166A of the IPC, failure on part of public servant to record first information report in acid attack cases has been made punishable with the rigorous imprisonment for a term which shall not be less than 6 months, but which may extend to 2 years, and such public servant shall also be liable to fine. Section 54A of the CRPC makes provisions for persons who are suffering from physical disability to identify the person arrested, under the supervision of a judicial magistrate who shall take appropriate steps to ensure that such person identifies the person arrested using methods that person is comfortable with. The proviso to this section further provides for such identification process to be videographed. Subsection 1 of Section 154 of the Code of Criminal Procedure has made reporting convenient for women by making it mandatory on part of state to make arrangements for women police officer to record information regarding offences of acid attacks against women, where the informant is herself the victim of such assault or attempted assault. Further, we have provisions for regulation of acid sales. The Model Poisons Possessions and Sale Rules of 2013 have been framed under the Poisons Act of 1919 to regulate sale of acid and other corrosive substances. The model rules include, among others, the form of acids, liquids or crystalline and its concentration that can be stored and sold, issue of licenses, procurement by individuals, educational and research institutions, hospitals, industries, government departments and departments of public sector undertakings. According to Section 5 of the Poisons Act 1919, any substance specified as a poison in a rule made or notification issued under this Act shall be deemed to be a poison for the purposes of this Act. The list of poisons supplied in the schedule to the Model Poisons Possession and Sales Rules 2013 declares certain acids as poisons and their sales and possession have to be regulated in accordance with the Poisons Act 1919 and the rules made thereunder. Then we have a victim compensation scheme under Section 357A of the CRPC, which casts an obligation on the state government in coordination with the central government to prepare a scheme for providing funds to the victims or dependents of victims who have suffered loss or injury as a result of crime and require rehabilitation. Under Section 357B of the CRPC, it has been clarified that whenever the court awards payment of compensation to survivors of acid violence, the compensation payable by the state government under Section 357A shall be, in addition to the payment of fine to the victim under Section 326A of the Indian Penal Code. We also have a victim compensation scheme under Nirbhaya Fund. Record of disbursement made by states, union territories under their victim compensation scheme is not maintained centrally. However, on 6th July 2016, the central government launched a revised Central Victim Compensation Fund (CVCF) scheme for women with one-time grant of Rs 200 crore under the Nirbhaya Fund to support and supplement the existing victim compensation schemes notified by states and union territory administrations to reduce disparity in quantum of compensation amount notified by different states, UTs, for victims of crimes, and to encourage states and union territories to effectively implement the victim compensation schemes notified by them under the provisions of Section 357A of CRPC and provide financial support to victims of various crimes like sexual offences including rape, acid attacks, crime against children, human trafficking, etc. The National Legal Services Authority, NALSA, has launched a Legal Services to Victims of Acid Attacks Scheme 2016 on the occasion of Legal Services Day in November 2016 to provide legal assistance to acid attack victims and ensure that they are appropriately rehabilitated in the society. Now, victims of acid attack are also entitled to medical aid as a matter of right. Earlier, Clause 6 of Section 357A of the Criminal Procedure Code had provisions whereunder the state or the District Legal Services Authority could alleviate the suffering of the victims of crimes by ordering immediate first aid facility or medical benefits to be made available to the victim free of cost, subject to the production of a certificate of the police officer in charge of the police station or a magistrate of the area concerned, certifying such a requirement. After the 2013 amendment, now Section 357C of the CRPC provides for treatment of victims and makes it absolutely mandatory on the part of all hospitals, public or private, whether run by the central government, the state government, local bodies or any other person, to immediately provide the first aid or medical treatment free of cost to the victims of acid violence, and it also casts an obligation on such hospitals to immediately inform the police of such incident. Now, non-compliance with the provisions of Section 357C CRPC has been made a punishable offence under Section 166B of the Indian Penal Code. Thus, where a person in charge of a hospital, public or private, whether run by the central or the state government, local bodies or any person, contravenes the provisions of Section 357 CRPC, that is, when they either refuse to administer first aid to victims of acid violence or when they charge money for the same, or if they fail to inform the police regarding such incident, then the law provides that such person will be punished with imprisonment for a term up to 1 year or with fine or with both. There is an additional duty on the doctor to inform the police. The Criminal Laws Amendment Act of 2013 has introduced Section 357 in the CRPC, which makes it mandatory for all hospitals, public or private, to immediately inform the police of any incident of rape or acid attack when they receive any victim of these offences for treatment. Thus, reporting has been made a legal duty. Now it is no longer a mere moral obligation. Further, Section 357C of the CRPC casts a twofold obligation on the hospital administration. First, they have a duty to provide immediate first aid treatment, and that too free of cost to the victim of acid attack. And then they are duty bound to immediately inform the police of such incident. Non-compliance with provisions of 357C has been made a punishable offence under 166B of the IPC, which is punishable. Now, we have also made taking testimony of acid attack survivors simpler. Section 119 of the Indian Evidence Act has been amended, and now it has made provisions for witnesses who were unable to speak to give their evidence in any other manner in which it can be made intelligible, as by writing or by signs, but such writing must be written and the signs should be made in open court. The evidence so given in writing or signs shall be deemed to be oral evidence. The proviso to Section 119 further provides that if the witness is unable to communicate verbally, the court shall take assistance of an interpreter or a special educator in recording the statement, and such statement shall be videographed. Now, this provision is particularly helpful for acid attack victims because more often than not we have seen that the face of a victim is targeted, and this causes the lips to melt, due to which the victims are unable to speak. But if they are allowed to give evidence with the help of signs, in writing or with gestures, then it comes quite handy. Under Section 114 of the Indian Evidence Act, the court may presume existence of certain facts. It provides that the court may presume the existence of any fact which it thinks likely to have happened, regard being had to the common course of natural events, human conduct, and public and private business in their relation to the facts of the particular case. This section can be employed in prosecutions of acid violence, as the victim might be the sole witness of the incident, or other eyewitnesses might be reluctant to depose against the accused. The accused may flee the spot and also take away the means in which he carried acid, due to which recovery of weapon of offense might be difficult. In such a scenario, if circumstantial evidences point towards the involvement of the accused, the courts may convict him with the help of Section 114. Thus, we see that now we have got so many legislative provisions and schemes of the government wherein the seriousness of our lawmakers and the government is evident that yes, they want to control the rising incidents of acid violence. In the case of Parivartan Kendra versus Union of India, the Honorable Supreme Court observed that these attacks have been rampant for the simple reason that there has been no proper implementation of the regulations or control for the sale, supply and distribution of acid. There have been many cases where the victims of acid attack are made to sit at home owing to their difficulty to work. These instances unveil that the state has failed to check the distribution of acid falling into wrong hands, even after giving of many directions by the court in this regard. Henceforth, a stringent action should be taken against the erring persons supplying acid without proper authorization, and also to all those concerned authorities who are involved in the sales, regulations and supply. And all those authorities should be made responsible for failure to keep a check on the distribution of the acid. It is pertinent to mention here that the mandate given by this court in Lakshmi's case nowhere requires or restricts the court from giving more compensation to the victim of acid attacks, especially when the victim has suffered serious injury on her body, which is required to be taken into consideration by this court. The court accepted that enhancement of the compensation amount would be an additional burden on the state, but further it is important to pay this enhanced compensation because it is the full responsibility of the state to get the victim treated and rehabilitated properly as per the guidelines which were provided in Lakshmi case. So, this court has additionally directed all the states and union territories to consider the plight of such victims and take appropriate steps with regard to inclusion of their names under the disability list. So you see, acid attack is one of the most horrifying form of violence against women. Although this is a crime which is gender neutral in nature, but majority of the victims of acid attacks are women. And we have seen that in acid cases, there is a marked gender skew. After 2013, now we have legislative provisions in place. We have got landmark judgments in the case of Lakshmi versus Union of India and Parivartan Kendra versus Union of India. All these are indicative of the iron hand with which we want to put a curb on incidences of acid violence against women in our country. Let us hope the incidents of acid violence, they abate in the days to come. Thank you.